So let's get started. So as I said, the session today is on both Brexit and COVID implications for immigration. And for those of you who don't know, my name's Elaine McIlroy. I'm a partner in the Employment and Immigration team at Brodie's. And today I'm going to be speaking along with my colleague Erin McLafferty, who's a solicitor in the team as well. And the agenda for today is to cover 3 topics, which are on the slide. And we'd found that lots of employers, I guess, had been progressing smoothly with their Brexit planning processes. They'd been delivering workshops for EU nationals on the settlement scheme or communicating with their staff about that. Some had been thinking of applying for sponsor licenses for the first time with a view to the new rules coming into force on the 1st of January. Others were sort of preparing and reviewing their compliance processes, bearing in mind that they might need to increase the number of people that they sponsor going forward. And then COVID hit, and everybody's attention turned to that for a few months, which is entirely understandable. But what we've been seeing over the last few weeks is people turning their attention back to Brexit planning and the 1st of January next year and what to do about that. So today's session is going to cover sponsor licenses, key compliance issues for employers, for both those who are going to be putting in place a sponsor license for the first time, and also a recap for those of you who've already got one. We thought it'd be a good time to do a refresher on that. I'm then going to talk a bit about the EU settlement scheme. We've had some queries in about managing EU nationals who might be absent from the UK for COVID-related reasons. So we thought it would be useful to touch on that and some recent changes to the rules. And then I'll finish off by talking about the UK quarantine rules, which are coming in on the 8th of June. So good timing-wise, hopefully, for a quick refresh on that. So I'll hand over to Erin now for the first session.
Thanks. So as Elaine mentioned, I'm going to speak about sponsor licenses and how things are changing from the 1st of January 2021 and some of the kind of compliance things that sponsors should be aware of. So while everyone's been kind of focusing on COVID, Brexit has been kind of ticking along in the background, and we are currently in this standstill period. So for now, EU nationals can continue to live and work in the UK without any prior visa permission, but that will come to an end on the 31st of December this year. And in the midst of COVID, the government has confirmed some of the new measures that will come in place on the 1st of January in relation to that. So the government have confirmed that new immigration routes will open from autumn 2020 in anticipation for applications to work, live and study in the UK from the 1st of January 2021. These routes under the new system will cover medium-skilled roles for the first time, and they will also be subject to a lower minimum salary than is currently in place. So the new minimum salary will be £25,600, and it may be lower in some cases. And the kind of key thing to bear in mind about all this is that the new routes will apply to EU nationals for the first time. And that is a big change, and we do expect therefore that lots of different employers who maybe don't currently sponsor migrant workers may have to in the future. So currently licence applications, which you must have in place, so you must have a licence in place to sponsor migrant workers, those applications are taking around 8 weeks. But we are expecting a surge in the second half of the year as everyone kind of rushes to get their licenses in place for the new system coming into play on the 1st of January. And we're also anticipating that COVID will have impacted processing in some cases, just as everyone is logistically being impacted by that. So the recommendation at the moment is to go ahead and think about whether you need a licence, and if you think you will, get the applications in ASAP. The guidance was kind of to start looking at it around summer, but we're almost there now, we're in June. So if you think there is a need for a licence, definitely go ahead and get thinking about starting that application. And with that in mind, we thought it would be useful to go through some of the compliance obligations that employers might have to think about, either for those that are applying for a licence for the first time or those who have a licence and are expecting a kind of surge in use from the 1st of January. So first of all, I'm just going to chat through some kind of key facts on sponsor licenses. When you first apply for a licence, you are granted it for an initial period of 4 years, and the whole point of the licence is to split the responsibilities and compliance responsibilities between both the employer and the individual being sponsored. UKVI have also been quite strict sometimes in the past with revoking licences or suspending licences, and it's important to bear in mind that UKVI take compliance with obligations under the licence very seriously. So those that do sponsor have obligations to report certain information and to kind of keep certain documents for migrant workers. And the courts in the past have been very hesitant to kind of interfere with UKVI's decisions to revoke licences where there's been non-compliance. And the message in the courts is very much that being licensed is a privilege and not a right. So even if your organisation is heavily reliant on the licence to sponsor migrant workers, everyone has an obligation to comply with their obligations, and it's certainly not a right to have a licence. It's also not rocket science, so the things that you're asked to do are not terribly difficult, but they are easy to breach if you don't have systems and processes in place, and you should be auditing and reviewing those systems regularly to make sure that everything is up to speed. So next, I'm going to look at the things that you must be to have a licence. Firstly, you have to be a genuine organisation operating lawfully in the UK, and UKVI kind of test that through the application stage. So there's certain documents that you must submit that come from a long list UKVI published, and you must submit those documents alongside your application. You also have to be honest, dependable and reliable. So there's certain people that you allocate to the licence, and those people have to not have a criminal record, and they also have to not be subject to any kind of bankruptcy or debt relief order or anything like that. You also have to be capable of carrying out sponsor duties, so you have to be capable of having processes in place, of reporting certain things, and of keeping certain documents, and the way you show that's kind of through your processes and things like that. And finally, you have to be able to offer jobs eligible for sponsorship. So from the 1st of January, you will be able to sponsor both medium and highly skilled roles. You can certainly apply for a licence now, but you can't actually sponsor medium roles till the 1st of January. But if you can show that you can sponsor roles at that level, then you will be able to apply for a licence. So I mentioned briefly there something about key personnel. So I'll run through key personnel on the licence. When you apply for a sponsor licence, you have to identify certain people within your organisation to undertake key roles. I'll just run through these really briefly. So these are the authorising officer, and that is usually the most senior person in the organisation who manages recruitment and is kind of on top of all the migrant workers and ensuring that sponsor duties are met. We do training separately on authorising officers and their obligations, but that at a very high level is what that person does. There's then the key contact, so that's the person that's responsible for day-to-day management between UKVI and the employer. That can be the same person as the authorising officer, or it can be someone different. And then you have the level 1 and 2 users, and these are the people that are the kind of day-to-day do the day-to-day roles with sponsorship. So they are the ones that access the sponsor management system, which is the online system that you get access to when you're a sponsor. And you kind of do all the reporting and you do the kind of practical things when it comes to sponsoring someone. And the only difference is level 2 have slightly less access and slightly more restrictions than a level 1 user. Just some key things on that. All key personnel must be permanently based in the UK. They must meet the requirements in criminal convictions and bankruptcy and debt orders, as I mentioned. And they must also be paid members of staff or paid office holders. And the only exception to that is that your level 1 user can be a representative, so a solicitor or a HR representative, but you must also have a level 1 user in place who is a paid member of staff. Just going to quickly talk about compliance issues with key personnel. So email addresses must be secure and accessible only by that person, so no shared inboxes. Level 1 users should also access SMS regularly, and that's something a lot of employers don't actually do. In our experience, we find that some sponsors don't check the system regularly. There's a notice board on there, and UKVI use that as their kind of main way to communicate with sponsors. So there's lots of handy information in there, and you certainly should be accessing it as frequently as possible, but at least once a month. Passwords for level 1 users shouldn't be shared. So that's why we kind of encourage employers to make sure they have more than one level 1 user, because if you have a level 1 user who's out of the business, either for sickness reasons or maternity or paternity leave, someone can't use their account and just log in with their password. UKVI do not like that at all. So it's always worth making sure you have 2 people with logins, so that you can kind of, if there's ever a reason for one to be out of the organisation, you're covered in that circumstance. There's also very strict rules about certificates of sponsorship, which are the kind of electronic documents that facilitate sponsorship, and there's very strict rules on when you use them and what one you use. So it's important for all your staff on the licence to know when and what they should be doing with that, and UKVI take breaches in relation to that very seriously. And finally, if there's a failure to have an authorising officer or level 1 user in place, that's a serious breach. So it's important to have leavers processes in place. So if your authorising officer resigns, making sure that as an employer you have a process in place to replace that person on the licence, and certainly don't wait till their last day in the organisation. Make these applications to change the users as soon as possible, because these things are not instantaneous with UKVI. So next I'm going to look at why is it important to comply with your obligations, and there's 3 main areas of risk. Firstly, the financial risk. So fines for illegal working, as I'm sure a lot of you know, are pretty big and can cost a lot of money, and there's also fines if you're found to not be complying with your obligations on your licence. There's also an operational risk, and this is a particular problem for sponsors who are heavily reliant on migrant workers. So if you use your licence and you need to sponsor a lot of workers, if your licence is downgraded to a B, which means you can't sponsor new migrants, that could be a big problem. Or even worse, if your licence is revoked and it means that you lose the sponsored workers you've got in place and you can't sponsor migrant workers in the future, that could really be an operational disaster for your organisation. And also there's a reputational risk. So UKVI published illegal working breaches, and there's been many cases in the past of employers finding their names all over the papers because they've been found to have illegal workers. So I'll look now at the 5 areas of the HR processes that UKVI look at. So UKVI can and do undertake audits of their sponsors, either before the application is made or at any point after, and they're almost always unannounced. So it's really important to have these 5 areas of processes in place and to be prepared for a visit at any point. When UKVI come, they do hope to see these processes, and they will do a kind of compliance audit to make sure that they are that they do the job and that they are ticking the boxes they're supposed to be doing. So I'll chat through these really quickly, but the important thing is to be auditing your processes yourself. It's much better for you to do an audit and identify a problem and rectify that than for UKVI to come in and find a problem, because then you might find yourself in a bit of hot water. So the first one is preventing illegal working, which seems obvious, but that includes things like right to work checks, and we recommend that employers have as a minimum an illegal working policy in place, and they have a diary system in place for follow-up checks and things for right to work. And it's really important to audit that and spot check your files regularly, because things do, in our experience, fall between the cracks sometimes. Secondly, maintaining contact details. There is an obligation on sponsored employers to keep up-to-date details for their migrant workers, and this is slightly maybe above and beyond what you would do for your non-migrant workers, but you should have a note of any change of addresses or new phone numbers, and it's good to have a migrant worker policy in place that obliges your migrant workers to inform you when they change these things, because it's not something you would maybe necessarily know of through employment. Thirdly is the record keeping obligations. So UKVI have a document and it's called Appendix D, and it's a comprehensive list of everything they expect you to have on file for your migrant workers. Some of it again is a bit above and beyond what you would probably have for your normal non-migrant workers. So it's good to have a note of that, use it as a checklist and check it regularly as it does update from time to time. Migrant tracking and reporting. So there are some organisations where HR just can't physically have oversight of all their migrant workers, so particularly in big organisations. So it's important for line managers to be aware of certain things that they have to report, and that they report them to HR or level 1 user. And that kind of chain of communication is really, really important, because there are certain things, if they happen to a migrant worker, they have to be reported to UKVI. So things like increases in salary, a change of a place of work, potential promotions. These things all need to be reported to UKVI, and if your line manager isn't aware to inform HR, these things could slip through the net, and there's very strict timing for reporting these things as well. And finally, general sponsor duties. So as well as reporting things on your migrant workers, the sponsor also has an obligation to report some specific details about themselves when they change. There's a very comprehensive list in the policy guidance, but generally these are things like changes of control, pay transfers, any insolvency measures taken, or any changes to the name of the sponsor. These could be reportable, so it's important to have a process in place so that if that happens, HR know when to report, and their level 1 user can access SMS and do what needs to be done. So finally, we have a slide here that I'm not going to take you through because most of it is what I've kind of covered, but it's just a checklist for you to take away and have. I suppose today's been a kind of taster of compliance issues with sponsor licenses. We do carry out comprehensive training and mock compliance audits like UKVI would carry out. But I suppose these are the key things you should be thinking about, so I'll let you take them away. And I'll now pass on to Elaine, who's going to chat about the EU settlement scheme and things to be thinking about in relation to that.
Thank you, Erin. So as Erin said at the beginning, we are in the midst of the transition period, which is a standstill period whereby freedom of movement still remains in place, and European nationals can still at the moment come to the UK, and they'll still be able to do that at any point up until the 31st of December this year at 11 PM, which is the cut-off date. So the UK obviously left the EU already on the 31st of January 2020, and there's been some discussion about whether the government might seek to extend the transition period. At the moment, they're saying they're not going to do that, or they're not going to ask for an extension, but we'll watch this space on that in case it changes. But for now, I think employers need to proceed on the basis that the transition period will come to an end at the end of the calendar year. And in any case, even if the transition period were to be extended for any reason, the government at the moment is planning to introduce the new points-based system from the 1st of January 2021. So I think that may well happen even if there were some sort of extension. But yeah, for now we need to plan around this short transition period, which was much shorter than originally anticipated at 11 months. And because of the COVID disruption, that has meant in practice it's maybe felt a bit shorter even, and we've only got about 7 months of it left to go at the moment. So moving on to my next slide, I thought it'd be useful to talk about what the end of the transition period means for employers. So EEA and Swiss citizens and their family members can of course still apply for leave under the EU settlement scheme. As I said, that cut-off date of the end of the year, people will have to be resident in the UK by that date in order to apply under the scheme, but there will be a grace period up until June 2021 whereby people can still make their applications. They don't actually have to have their paperwork in by the end of the year. But our strong advice to employers is to get your staff applying way ahead of time. There's no point waiting until those deadlines are about to pass. And actually there's obviously a clear benefit to your staff in having their paperwork in place, having been granted permission under the scheme well in advance. Because at the moment, if you are refused or rejected under the scheme, there's plenty of time to go and make a new application and to get your paperwork right. That won't be the case if you apply too late. If you apply after, for example, that close to the June deadline and then are refused, you'll be automatically illegal and not able to work at that point. So there won't be that window of being able to make a fresh second application. So for that reason, it makes sense to get your staff thinking about the settlement scheme again, focusing their attention on it and applying. COVID has disrupted the settlement scheme to an extent, along with everything else in the world that's been a bit disrupted in relation to it. So they still have been processing applications, but there's been a huge drop-off in applications, as you'll see from my next slide. So overall, they've made good progress. We've got 3.5 million people who've applied already under the scheme, but in April, unsurprisingly, it was only about 12% of the applications as compared to, say, October last year. So there was a huge drop-off with people just not focusing their attention on it. And that's fine for now because there's a bit of time to go, but it is important that people, as I said, don't wait till the last minute, because we could be sort of storing up a problem for later. And some of the statistics that have come out have shown that the Home Office has started refusing applications under the scheme. They did that for the first time in February this year, even though the scheme had been open since last March. And they say most of the reason for refusing applications is where people don't provide sufficient paperwork. So it's the kind of eligibility criteria that people are falling down on. And they've said when they've toed and froed with people and asked for that extra information, and eventually it hasn't come through, they've started to refuse people under the scheme. So although the requirements under the scheme aren't too rigid or tight, it is still possible to get it wrong, and for that reason, yeah, it makes sense to get your staff applying sooner rather than later. I thought it would be worth also just mentioning a slight change to the rules that you might have read about in the press just over the past few weeks. So as of 24th of August 2020, so this year, they're going to change the rules. So those from Northern Ireland were originally being treated as only British for the purposes of the settlement scheme. And that was despite the Good Friday Agreement, which had given them the right to identify as either Irish or British or both. And that was challenged. So now, as of August this year, non-EU family members of British or dual British Irish citizens from Northern Ireland can apply under the settlement schemes. You might have a few people in your organisation that might not be aware of that change. And it's much, much easier for them to apply under the settlement scheme than under a typical kind of spousal visa of some other sort. So just thought it'd be worth making you aware of that. And then managing EU nationals for now. So we've been asked some questions about this, so I thought it'd be worth covering it. So when people apply under the settlement scheme, they will either get what's called settled status, which is a type of indefinite leave to remain, and which is quite a secure immigration status. And they'll get that if they've had 5 years or more continuous residence in the UK. And actually that leave isn't kind of revoked unless somebody leaves the UK for 5 years or 4 years if you're Swiss. So it's quite a sort of permanent status once you've got that. But a significant number of people have been granted what's called a pre-settled status, and that's for those who've got less than 5 years continuous residence, and they get basically a 5-year fixed term visa to allow them to accrue sufficient residence that in the future they'll then be able to convert that or upgrade it, as it were, to a settled status. So that type of permission is less secure. And those individuals who need to be thinking about accruing their 5 years continuous residence need to be conscious and aware of any absences from the UK where those are significant absences, because a break of or an absence of 6 months in any 12-month period will break that period of continuous residence, meaning that they might never qualify for the more permanent indefinite leave to remain or settled status under the rules. And with COVID, what we've seen is some people either spending considerable periods of time outside the UK because they can't get back in, or possibly they're being allowed to work at home for such long periods that they've decided to go and live somewhere else in Europe, for example. And for those individuals, they do need to be thinking about whether they're breaking this period of leave, because the 6 months is cumulative or an aggregate. And on my next slide, I've mentioned there are some exceptional situations where you're allowed a one-off period of absence more than 6 months, as long as it's less than 12. And that has to be for what's called an important reason under the rules. And some examples that are in the rules are things like pregnancy or childbirth, serious illness, vocational training, or overseas secondments or postings. But certain COVID-related absences may not be covered by those important reasons and may not therefore be justified under the rules. So you could have staff who think that they're going to be okay for settled status eventually once they've got their 5 years, but they might actually have broken their period of residence. And there is a window of opportunity to kind of fix that at the moment if you've got staff who've got pre-settled status and who've got significant absences, in that provided they become come back to the UK before the cut-off of the end of the calendar year, so 11 o'clock on the 31st of December, if they were to apply for pre-settled status again and wipe the slate clean and then get a new 5-year visa, they would then have the opportunity to accrue their 5 years continuous lawful residence without having kind of damaged it with any prior period of absence. So something we're thinking about if you've got key staff or people that need to be able to apply in the future under the settlement scheme. I'll just move on from that because that's just covering what I've already said. So some practical tips for employers to take away. As I said, remind your staff to apply under the settlement scheme early. Don't leave it too late, or there could be a risk of illegal working issues and people having to be terminated, which is what everyone wants to avoid. Being mindful if people have got very significant absences, and now more than ever we're seeing lots of that happening in practice because of COVID. And then signposting staff to information sources if they're concerned about being able to qualify under the settlement scheme, and being aware of the fact that employers can't give immigration advice, but you can signpost people to government websites, etc. So finally, I'm just going to touch on the quarantine rules, which I'm sure most of you have heard about, which have been in the press and have been quite controversial, quite heavily criticised, but they're part of the COVID-19 recovery strategy, and they will apply from the 8th of June 2020, initially for a period of 3 weeks, and then they're going to be reviewed. I would expect those to stay in place longer, albeit that they might start to adjust the specific requirements under the rules. But basically they require any individuals coming to the UK, whether they're UK citizens or otherwise, to self-isolate for 14 days on arrival. And if you breach the rules, it can be a criminal offence. There'll be a penalty of £1,000 for a breach. And also there's the potential to remove people. So for example, if you had business visitors come in and breach the rules, they might be removed, and it could also adversely impact any future applications to come back into the UK. So definitely worth making people aware of them so that they can comply. And for those coming to the UK, they'll be asked to complete a contact locator form on arrival, saying where they're going to be residing for their quarantine period. And there's certain specific exemptions to that for defence sector, etc., which are in the rules. But generally, everyone will have to comply with these. There are a limited number of exceptions for specific jobs, and there is a list on the government website for that. So if you work in road haulage, certain medical professionals and fruit pickers, for example, are going to be exempt from the rules or have slightly different rules apply there, but it's worth checking the list. And in terms of practical recommendations for employers from these quarantine rules, if you're hosting business visitors, and I guess we've seen less business travel than usual just now, but I'm sure that will ramp up over the coming months, make them aware of the new rules. It's likely that they will have to be put up in specific accommodation that will allow them to comply with the rules, and they'll be asked to provide the address of where they'll be staying. They are only going to be able to leave that accommodation for the reasons on the slide, so urgent medical treatment, emergencies, funerals, etc. is pretty limited. And also think about arranging transport for them, because they're being advised not to use public transport if at all possible, coming from the airport to wherever they're going to be quarantining. And for those of you who've got employees who want to go on holiday, which we might see increasing requests for that over the coming months, they might be impacted by the quarantine rules as well. So discussing with employees in advance what they're going to do in the quarantine period when they return. For those who can work at home, that might be pretty straightforward, but for others, you might want to discuss what pay arrangements will be in place for them. So let's move on to the questions. I think there are a couple that we've got through in the chat box, but do you have any, Erin?
Yeah, so here's one that says, how likely is it we would get a compliance visit before getting a sponsor licence, and how would that impact timing?
So at the moment, yes, UKVI are saying from the point where you submit your paperwork, and I would say that could take a bit of time in the midst of COVID to get time to get all your paperwork together, because they like you to submit originals and certified copies of documents. So from the time they receive that, they're saying roughly 8 weeks to process a licence application. They will sometimes deal with licence applications more quickly if it's urgent. but with COVID, it may be that there is a bit of a backlog and we might see a bit of a surge of applications all at once. But yes, they have the right to carry out a compliance visit before they grant the licence. I don't think they'll be carrying out any compliance visits at the moment, so that may well put things on hold or cause further delays. So factoring all of that into the timing is important. At the moment, there's several months to go till the new rules come into place, but for those employers who don't have sponsor licences, yeah, doing it sooner rather than later will mean, even if there's delays for compliance visits or whatever, that shouldn't hold things up too much. There's a question here, is it still the case that EU nationals can enter the UK before December 2020 and be eligible for the settlement scheme without the requirement for employer sponsorship? The answer to that is yes. Before that cut-off, those individuals will be eligible under the settlement scheme, and there's massive advantages to that in that they don't have to pay for it, whereas if they come in from the 1st of January onwards, they'll be subject to many thousands of pounds visa fees, health surcharge, the employer's skills charge and everything else, and they would also be restricted in terms of what jobs they can do. So there's a huge advantage to getting people in before that cut off without the sponsorship need. Do you have any others, Erin?
Yeah, so there's one more. If you have a sponsor license already and actively sponsor a number of employees, is there a requirement to do anything to refresh or upgrade the license based on the new rules, or will everything continue as it is?
Do you want to answer that one then?
Yes, so I suppose at the moment, the biggest change is to who's going to be eligible for sponsorship. So I guess you're right in that there's no requirement to refresh or upgrade your license. The license will stay the same, and if you've got one in place, that will continue to be relevant. I suppose if you don't have a license, that's where you've got the biggest change. But I suppose all your policies and procedures will have to just expand slightly to any future EU nationals that you sponsor in the future, so you'll kind of widen it. But I suppose if you've got the processes in place, then you don't need to be doing much else.
Yeah, and nothing major is changing in relation to the compliance processes, but I would say it'd be worth doing a bit of an update on the new rules, who can be sponsored and who won't be eligible for sponsorship going forward, because there's significant changes in place for all of that, which will impact timing, eligibility. They're abolishing the resident labour market test and whatever, so a sort of refresh on what the new rules will be would be sensible for anyone kind of operating the sponsor management system. Okay, that's about 3 minutes after, so we'll conclude the session, but thanks for attending, and if you've got any further questions, please do pop them in the box with your name and we'll try to get back to you after the session. Thank you.
Thanks.